Boy, it gets more exciting each day. More exciting. So, welcome. We are back on the record in cause number F1900289. As we left off yesterday and discussed on yesterday, we are now going to have the closing arguments of the state of Texas versus Billy Shamirmir. Yesterday, the state of Texas closed and rested their case, as well as the defense closed and rested their case. So, as we have discussed on yesterday, I will read the court's charge. After reading the court's charge, you will then hear from the state of Texas. You will hear from defense counsels, and then the last voice that you will hear in regards to closing arguments will be of the state of Texas. Cause F1900289, the state of Texas versus Billy Kipkor Shamirmir. Court's charge. Members of the jury, the defendant, Billy Kipkor Shamirmir, stands charged by indictment with the offense of capital murder alleged to have been committed on or about January 31st, 2018 in Dallas County, Texas. To this charge, the defendant has pleaded not guilty. The following instructions are the law applicable to this case. You are instructed that you may read these instructions as a whole. Offense definitions. A person commits murder if the person intentionally or knowingly causes the death of an individual. A person commits capital murder if the person commits murder as that term is herein defined, and the person intentionally commits the murder in the course of committing or attempting to commit burglary or robbery. A person commits burglary if, without the effective consent of the owner, the person enters a habitation and commits or attempts to commit a felony, theft, or an assault. A person commits robbery if, in the course of committing theft, as that term is herein defined, and with intent to obtain or maintain control of the property of another, the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits theft if the person unlawfully appropriates property with intent to deprive the owner of the property. Term definitions. Actor means a person whose criminal responsibility is an issue in a criminal action. Another means a person other than the actor. Appropriate means to acquire or otherwise exercise control over property other than real property. Appropriation of property is unlawful if it is without the owner's effective consent, or the property is stolen and the actor appropriates the property knowing it was stolen by another. Attempt. To commit an offense occurs if, attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to affect the commission of the offense intended. Bodily injury means physical pain, illness, or any impairment of physical condition. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value of enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether express or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by force, threat, or fraud. Felony means any offense so designated by law or punishable by death or confinement in a penitentiary. Habitation means a structure or vehicle that is adapted for the overnight accommodation of persons and includes each separately secured or occupied portion of the structure or vehicle and each structure appurtenant to or connected with the structure or vehicle. In the course of committing theft means conduct that occurs in an attempt to commit during the commission or an immediate flight after the attempt or commission of theft. Individual means a person being who is alive. Means a human being who is alive. Owner means a person who has title to the property, possession of the property, whether lawful or not, or a greater right to possession of the property than the person charged. Person means an individual. Property means tangible or intangible personal property, including anything severed from land or a document, including money, that represents or embodies anything of value. Possession means actual care, custody, control, or management of property. Steal means to acquire property or service by theft. Mental state definitions. The following definition applies to the offense of capital murder. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. The following definitions apply to the offenses of burglary, robbery, and theft. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care, and that risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the actor's standpoint. Capital murder. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about January 31st, 2018, in Dallas County, Texas, the defendant, Billy Kipkor Shamirmir, did intentionally cause the death of Mary Brooks, an individual hereinafter called deceased, by homicidal violence with a deadly weapon, the exact nature and description of which is unknown and unknowable to the grand jury, or by smothering the deceased with a pillow, a deadly weapon, or with hands, a deadly weapon, or with an unknown object, a deadly weapon, the exact nature and description of which is unknown and unknowable to the grand jury, and you further find beyond a reasonable doubt that the defendant was then and there in the course of committing or attempting to commit the offense of robbery of said deceased, then you will find the defendant guilty of capital murder as charged in the indictment. Or, if you unanimously find from the evidence beyond a reasonable doubt that on or about January 31st, 2018 in Dallas County, Texas, the defendant, Billy Kipkor Shamirmir, did intentionally cause the death of Mary Brooks, an individual hereinafter called deceased, by homicidal violence with a deadly weapon, the exact nature and description of which is unknown and unknowable to the grand jury, or by smothering the deceased with a pillow, a deadly weapon, or with hands, a deadly weapon, or with an unknown object, a deadly weapon, the exact nature and description of which is unknown and unknowable to the grand jury, and you further find beyond a reasonable doubt that the defendant was then and there in the course of committing or attempting to commit the offense of burglary of said deceased, then you will find the defendant guilty of capital murder as charged in the indictment. If you do not so believe, or if you have a reasonable doubt thereof, or if you are unable to agree, you will then consider whether the defendant is guilty of the lesser included offense of theft. Theft. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about January 31st, 2018 in Dallas County, Texas, the defendant, Billy Kipkor Shamirmir, did then and there unlawfully appropriate stolen property, to wit jewelry of the value of $2,500 or more, but less than $30,000, the said property having been stolen from Mary Brooks, its lawful owner, and the defendant acquired said property knowing that it was stolen property, then you will find the defendant guilty of the lesser included offense of theft. If you do not so believe, or if you have a reasonable doubt thereof, you will follow the following instructions. If you should find from the evidence beyond a reasonable doubt that the defendant is guilty of the charged offense or of a lesser included offense, but you have a reasonable doubt as to which offense he is guilty of, then you should resolve the doubt in the defendant's favor and find the defendant guilty of the lesser included offense. It is not necessary for you to acquit the defendant of the greater charge in order to consider a lesser offense contained in the court's charge. If you believe the defendant is not guilty of any offense or have a reasonable doubt thereof, then you will acquit the defendant and say by your verdict not guilty. Presumptions and burden of proof. In all criminal cases, the burden of proof is on the state. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless you are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case. The state has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. This burden rests upon the state throughout the trial and never shifts to the defendant. If the state fails to meet its burden, you must acquit the defendant. It is not required that the state prove the defendant's guilt beyond all possible doubt. It is required that the state's proof excludes all reasonable doubt concerning the defendant's guilt. In the event that you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit the defendant and say by your verdict not guilty. Evidentiary instructions. You are instructed that you are not to allow yourselves to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. The court has no right by any word or any act to indicate any opinion respecting any matter of fact involved in this case, nor to indicate any desire respecting its outcome. The court has not intended to express any opinion upon any matter of fact in this case. And if you have observed anything which you have or may interpret as the court's opinion upon any matter of fact in this case, you must wholly disregard it. At times throughout the trial, the court has been called upon to pass on questions of whether or not certain offered evidence might properly be admitted. Do not be concerned with the reasons for such rulings and draw no inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court does not determine what weight should be given such evidence, nor does it pass on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you of course must not consider the same. As to any question to which an objection was sustained, you must not conjecture to what the answer might have been or as to the reason for the objection. You are instructed that if there is any testimony before you in this case regarding the defendant's having committed an offense other than the offense alleged against him in the indictment in this case, you cannot consider that testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offense, if any was committed. And even then, you may only consider it in determining the motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident, if any, and for no other purpose. You are instructed that the defendant may testify in his own behalf if he chooses to do so, but if he elects not to do so, that fact cannot be taken by you as a circumstance against him or prejudice him in any way. The defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. You are further instructed that the state is not required to prove the exact date alleged in the indictment, but may prove that an offense, if any, was committed on any date prior to the presentment of the indictment and within the period of limitations. The indictment in this case was presented on May 14th, 2019. Concluding instructions. It is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he may have heard regarding the case from any source other than the witness stand. In deliberating on this case, you are not to refer to or discuss any matter or issue not in evidence before you, and you are not to talk about this case to anyone not of your jury. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive and follow the law from the court. After you have retired to consider the verdict, no one has any authority to communicate with you except the bailiff who has you in charge. You may communicate with this court in writing, signed by your presiding juror, through the bailiff who has you in charge. Do not attempt to talk to the bailiff, the attorneys, or the court concerning any question you may have. After argument of counsel, you will retire and select one of your members as your presiding juror. It is the duty of your presiding juror to preside at your deliberations and to vote with you in arriving at a verdict. Your verdict must be unanimous, and after you have arrived at your verdict, you may use one of the attached forms by having your presiding juror sign the particular form that conforms to your verdict. And it is signed by me, Judge Raquel Rocky Jones, presiding judge of the 203rd Judicial District Court here in Dallas County, Texas. After you have selected your foreman, you will have 3 verdict forms you may choose from on the very back. The very first verdict form reads, "We, the jury, unanimously find the defendant guilty of capital murder as charged in the indictment." There is a signature line for the presiding juror, and then there's a line for the presiding juror to print their name. The next verdict form reads, "We, the jury, unanimously find the defendant guilty of theft as included in the indictment." And there is a signature line for the presiding juror, and then there is a line for the presiding juror to print their name. The last verdict form is, "We, the jury, find the defendant not guilty." And there is a line for the presiding juror to sign their name by signature, and then there is a line for the presiding juror to print their name. So, State of Texas, are you ready to proceed in closing?
Yes, Judge.
Defense, are you ready to proceed?
Defense is ready, Your Honor.
All right, thank you so much. So, Mr. Crusoe, you may begin.
Thank you. May I please support?
You may.
Well, good morning again. Good morning. Hope you are well. On behalf of the District Attorney's Office and my staff, I want to say thank you for a number of reasons. And on behalf of the defense, I know they share the same thanks and appreciation for you being here every week. Okay? Let's talk about what happened. There was a day some few weeks ago where you all got something in the mail that said show up on a certain date, right? We know you didn't do a dance and didn't play any happy tunes when you got that, but nonetheless it started the process. And it started a process that determined 14 very special individual people, the 14 of you. Because most people who get that summons don't show up, but you did. And for that we're grateful and thankful. The other thing that happened is, and I think it was Judge Chapman, am I correct, Judge?
Yes.
Okay, Judge Chapman visited with me early in the morning, and she went over things we call them exemptions and disqualifications, and a certain number of people moved on. And then we had a chance to talk to you. And then we talked about the very special nature of who we are and what we do and why we are here. And we talked about constitutions, the United States Constitution, and we talked about a Texas Constitution, and then we talked about a penal code, we talked about elements of an offense, we talked about very special rights that a person accused is afforded here in this country. And I think it has become abundantly clear to you, not only a week ago today, but everything that has intervened in between, that we are supportive of those rights, we respect those rights, and we're going to make certain that everybody follows it. Because if you remember back to last Friday, anybody who couldn't give the defendant the benefit of whatever, they're not here. And so we're left with the 14 best folks, fairest folks that showed up. Okay? What else did we talk about? We talked about circumstantial evidence versus direct evidence. And you know now, right, after we talked about it, we talked about how sometimes people have been convicted and incarcerated for extended periods of time based on what? Direct evidence that was dead wrong. Okay? And it's circumstantial evidence that came back and saved the day. We also talked about how does evidence get left? Who's in control of the evidence? Okay? You, me, some stranger? No. The perpetrator of the crime determines what's left. Okay? Sometimes to their benefit, and sometimes to their demise. We got plenty of that in this case. And we talked about that. Okay? And we asked you a very specific question that has caused you to be here today. And you'll notice nowhere in the court's charge of the word circumstantial evidence or direct evidence. It's just, did we prove the case beyond a reasonable doubt? That's all we have to do. But we put something up and said, if we prove a circumstantial evidence case beyond a reasonable doubt, even if we did that, would you be unable or unwilling to follow the law and return a verdict of guilty? And everybody who said they couldn't do it, guess what? They're not seated where you are today. And I can go on and on through the legal things that we talked about. But the bottom line is that the 14 of you told us some things. First of all, you told Judge Chapman, and you told this judge also, that you will true answers give to all the questions propounded to you by the court or under its direction. That's us. Okay? You said that. And that's what makes us very special and very different from anywhere else. And you said you would, and we counted on you. We gave you questions, we took your answers, we counted on you last Friday, and we're counting on you today. To do what? Follow the law. That's all. Remember I told you we didn't need any help, didn't want it, don't need any favors? That's not what I'm talking about. Just follow the law. And then when you got up here, when you became even more special, to be one of the jurors, the judge gave you another oath that said you will true verdict render according to the law and the evidence and help me God. And you all stood up and you raised your right hands and you all said yes. And we were counting on you when you said that, and we're counting on you today. Okay? And I think that's reasonable and fair. That's what makes us special in this country. And that's something that other people fight and die about. I want to talk to you a little bit about the court's instructions. The judge called it, and at the top of it, it says the court's charge. I just want to substitute, just for argument's sake, the word charge with instructions. Okay? What is this? What is this document? Well, first of all, it's not that long. It's not complicated. Okay? There's one or two things, maybe one thing that I'm going to go over that we didn't talk to you about because we have to wait till the evidence comes in to see where we are to do that. Okay? But the first thing, on or about. We told you, and we used the example of the Lake Mead, or you leave and somebody steals your car, or whatever, and you find it. You don't know when it got out of there, when it left your house. Okay? And we don't have to prove the exact date. And there's a further instruction on that in the back that tells you that whether it's January 30th or 31st is irrelevant for questions of guilt. Okay? That's already in here. The other thing I want to go through is we went over the concept of robbery and burglary. Now you know why those are so important. I talked to you about an example of robbery, somebody on a bike, somebody knocks him over, takes the bike, that's a robbery. We talked about a burglary, entering a person's habitation. What's that? A structure adapted for overnight accommodations. All that's in here. Okay, with the intent to do what? Commit a felony, theft, or assault. That's in here. Okay, that's the difference between the two, and that's very important. Okay, but you said you understood it, you followed it. But also, when we go through this, we talk about deadly weapon. It means anything that in manner of use or intended use is capable of causing death or serious bodily injury. We have some things in here that says homicidal violence, smothering, hands, etc. Okay? And let's talk about this concept of a deadly weapon. What's the best proof that something is a deadly weapon? The person is what? Dead. And you got death after death after death after death. Or at least one survived only. The lovely Miss Bartell survived only because she was lucky enough to do what? Have a pacemaker. Other than that, he wouldn't have been able to take a deposition from her. and we wouldn't have found out how this goes down from person to person and time to time. So we covered that. Then I want to go through a little bit, and starting on page 5, and it goes on over to page 6. It starts the definition of capital murder. Now this, the bottom of page 5, right here, capital murder, and all the way to the bottom of, almost to the bottom of page 6. Those are what we call the application paragraphs. Okay, those are the 2 paragraphs, along with the rest of the instructions. But as far as capital murder is concerned, those are the 2 application paragraphs, and they read almost the same. Okay? And so it starts off by saying, on or about January 31st, 2018, in Dallas County, Texas, Village of Miramir, to intentionally cause the death of Mary Brooks. Intentionally. Let's talk about that. You heard the evidence from the doctor, Dr. Bernard. We went a little further, as if you couldn't tell from the evidence. We went beyond what a reasonable inference and deduction from the evidence. And we put medical testimony on about what it takes to smother a human being down. And you also heard from Mary Bartell, what she went through. Okay? And you know what it takes. It's not quick. It's not easy. People are fighting for breath. And beyond that, they're fighting for life. Can you imagine, like these ladies, you're in your home, and most likely a pillow is placed across your face and neck to such a degree and extent that poor Mary Bartell had one free hand, and the pressure was so intense that she couldn't even get her hand on her medical alert, which probably would have stopped her. Remember you heard her say the blaring noise, etc.? Can you imagine? Can you imagine that you have opened your door and immediately recognize that you made a mistake, and you immediately are told to go back, be quiet, and you're on the bed and a pillow is put across you? The amount of shock and fear that will go through a person thinking the reasonable thought, and she told you, she thought it was the end of it. And you know what? It was. Except for what? A basement. Okay? So you know how that's how this works. But when we talk about these 2 paragraphs, application paragraphs, they have the same words in them. Homicidal violence, the exact nature and description of which is unknown and unknowable. Who controls that? Not us. Or by smothering deceased with a pillow. Who controls that? Not us. A deadly weapon? You bet they're dead. Or almost. Or with hands, a deadly weapon. An unknown object, a deadly weapon. Etc., etc. And the first one goes and says, during or attempting to commit the offense of robbery. The only difference in the next one is the verb. Now, what did we talk about? And you said that you could do it, you could follow it, you understood it. So I want to revisit what we did a week ago. We told you, number 1, we didn't have to prove exclusively that it was robbery or burglary. Either one is okay, and it doesn't matter what your split is. And we also explained to you about homicidal violence and smothering and hands and the exact nature and description of things unknown to the grand jury. We didn't have to prove one of those to all 12 of them. Any combination, it doesn't matter where your numbers fall, any combination is good enough. Because all of it, any of it is what? Intentionally causing the death of an individual, either during a robbery or a burglary. That's all we have to do. And we asked you, could you follow that? You said you could. We trusted you last Friday, and we're trusting you today to be able to continue to follow the law that you indicated to us under a state of oath that you went at the time, that you could follow. And that's all we're really asking you to do, is to follow the law. Okay? Now, homicidal violence. Remember, we talked about some examples of homicidal violence. We talked about just as an example, the bodies found in Lake Mead, been there for decades. Okay? Gonna be hard in some instances, maybe, to come down. We talked about maybe a person who's found by the roadside with their head bashed in and nobody there, no implements or tools that can be readily discerned that cause the bashing in the head. They're dead. Okay? That would certainly fit what? Homicidal violence. Okay? Violence that does what? Causes the death of a person. And you certainly have that here, over and over and over. Then there's another particular paragraph I want to spend some time on to make certain that we're all on the same page. We didn't talk about this, okay, because we have to wait, see what the evidence is. The judge has to make a decision to put this together in a fashion that's legal and appropriate. She's done so. But on page 9, the bottom paragraph says you're instructed. Listen to this carefully. This is really important. This is important as anything else you're going to hear in this case. Okay? You are instructed that if there's any testimony before you in this case regarding the defendants having committed an offense other than alleged against him in the indictment in this case. 3 other cases. You cannot consider that testimony for any purpose unless you find and believe beyond a reasonable doubt, which is the law, that the defendant committed such other offense. And if any was committed, even then you may only consider it in determining what? Very limited. And we're okay with it. We're asking you to follow. The motive, the opportunity, the intent to cause death, staying on top of somebody with a pillow for multiple minutes until they die, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Okay? Follow that instruction and don't go outside the parameters of it, because this is the law. Any other considerations is inappropriate. Okay? Is that fair enough? Okay. Now, so where do we start here? Well, we start kind of with Mary Brooks. And you know, yesterday, one of the big presentations we made is we put all these up. You were almost like in a cocoon with maps, right? Yesterday. But these are the things, these exhibits, and they're kind of listed by date if you go through them one by one. January 30th, March 4th, 15th, 19th, and 20th. And of course, you've heard all this. You know what those dates are, how important they are, because they track activity. They track crimes. They track victims. They track intent. They track motive. They track plan. Okay? And not only did we have video and still camera, okay, but we learned some things about Mr. Shamir Mir, didn't you? And you started learning about Mr. Shamir Mir from Mr. Flink, whose mother, deceased today, was elderly and lived at 5000 Shepherd. And he went to get her at 10:30 or 10 or whatever. He came back at 12:30, whatever it was, about 2.5 hours. Okay? Take her to the doctor. Who did he notice? He didn't tell you a person. He didn't give you an identity. He gave you a car and a license plate. Who does that car and license plate go back to? Some kind of trick. Tom Oding really is the person. But you know from him who really drives the car. And even though the police tried to hit on the address of Tom Oding, when they started looking more deeply, they noticed that this car was up at Pear Ridge. Okay? So they started looking. They started following phones. They started doing things. Okay, but Mr. Flink told them what? He's out here for 2.5 hours. I wondered. I was concerned. I went out and spoke to him. Now, I'm just here to see my dad or something like that. Biggest lie you ever heard. Wasn't his dad. Okay? Well, what else did he say? He stayed out there. He moved the car. He went and got the license plate, turned it in. Like that. Okay? What else do we know? Well, that's kind of like surveillance, looking for victims. Doesn't it sound like that? Stalking. What else do we know? We know that he hangs out at the Walmart back and forth all the time. We know that he drives in and out. We know that he's capable of hanging out and in fact not capable, in fact doing what? Hanging out at the front, back and forth with a phone up to his ear that you heard from the evidence. Nobody's on that phone, not having a conversation with anybody. And he also doesn't mind helping elderly women with their baskets. That's nice. Good thing she had a man with her. Okay? But he is doing what? Surveilling and stalking. Okay? Think about it. What did Miss Harris do? Look after him. Where did he wind up? her house. We'll go into that. Okay? This is a conscious, dedicated effort to stalk, surveil, kill, steal, strip, and sell. That's his job. We all have work. I don't know what you do, whether you're working or not. We all have jobs. But I think the evidence has been quite clear what Mr. Schmiermeier's job is. Stalk, surveil, get inside, smother, strip your most precious valuables, family heirlooms. You notice all the junk stuff got left behind? Things got opened and closed. All right? Safe, box, whatever might contain some valuables. Get in it, toss it away. Okay? That's his job. A fundamentally different way of approaching what? Humanity. Okay? We go to work to produce. He goes to work to kill, strip, steal, sell. That's his job. So let's talk about what we wrote. Let's talk about Mary Brooks. The first thing, before I even get into all of this, is this idea. It's probably a little shocking to you to hear from this expert testimony, which your phone does, right? Probably didn't know all that. But sometimes it's necessary, and we'll only do it when it's necessary. And in this case, you had Special Agent said would tell you all about where I'm not going to go through all that. You just saw it yesterday. Okay? But he also told you, well, yeah, I'm not going to plot it in a certain place. I'll just tell you it's in that area. But he says sometimes it's extraneous or additional or extra evidence that will come in and do what? Validate or cross-validate. They'll validate each other. And you know, from time and time again, he's seen here at the apartments, bang, the phone is right here. At the Walmart, bang, the phone is right there. At this house, bang, the phone is right there. Other house, bang, the phone is right there. Okay? A ring gets somebody's ring that was recently taken off their finger just within an hour or so. It's taken on a hand and put on offer up. And you could look at that ring and tell it was valuable. And for a mere $380, shortly after choking somebody down, he's happy to move it on for the sake of $380. Okay? And you know Mary Brooks, that she was at the Walmart, she was in, he was parked, she came out, she left, he followed. Okay? The phone puts in there, moving towards her house, phone hitting near her house or at her house, and then of course you know the rest that went on. One of the most important things that came here was, what about this ring? Okay, well we went the extra step. We went and found not the person who did it, but the person who owned the place. And you notice when we put on that testimony that in his expert opinion, it's the same ring. There is absolutely no reason for you to doubt that. You know why? Because when we said pass the witness, what came from over here? No questions. Without doubt, expert testimony, unchallenged, unimpeached, uncontradicted, is what? It's the same ring. Okay? Let's talk about, let's go kind of on dates. Miss Martha Williams. This is where we come in to find out the plan, the identity, the motive, intent, etc., etc. Okay? Let's talk about that. She didn't go through her autopsy and have obvious signs of trauma, did she? From two inmates, the private one and the one for coming out. Okay? So that tells you that not all of these fall like that in the same way like Miss Harris did. All right? Or Miss Bartell, who got a red face over here, and a cut and a bruise on her nose. Okay? But what do we know? Phone is in the area, okay? And then the phone is where? Dallas Overland Exchange. The receipts show he sold items, and then in his car. Okay? And here's her pillow, when her daughters turned it over, obviously, The expert said hemoglobin. What did she say that is? A component of blood. Okay, let's reasonable inference, that's blood. Her blood. And they said it looked like the impression of a face. Whose face? Her face. It's her bed. She's dead right there. Okay? And so what do we know about that? Well, I don't know how to put 27 zeros on things. Okay? Might be beyond where I'm going. But I tell you what, that's an awful, an octillion is a whole lot that you got to go find. Okay? Not even the James Webb telescope can find all those planets. All right? Doesn't exist. Points to her. Let's forget about it. I don't need to talk. We talk about his DNA. We really don't need to talk about Mr. Shamir's DNA to solve this riddle. Okay? Why? Because when they go to his car and pull the gloves out, who else's DNA on one of those gloves? Glove number one that you heard. Unfortunately, poor Martha Williams. Wonder how he got in possession. His phone gets there, her jewelry, and all of a sudden in his car, the glove box, the car that he drove, the car that he enjoyed, the car that he surveilled and stalked and went from location to location to commit his crimes, how her, still in the octillions, her DNA got in that car. You know why? Because those gloves were an instrument of death. We use these gloves in here to not contaminate things. We use gloves to protect ourselves. We use gloves so we don't catch anything or give anything. That's not why he uses gloves. You heard from Mary Bartell. She can tell you one thing. One thing she can tell you. It's of average size, this, that, and the other, and what? Gloves. She said green, so what? Green, black, blue. Okay? But that's what she noticed. And that's what came after her. And so we have that case. To show what? Intent, plan, preparation, etc. And then, of course, I've talked about Mr. Plank, same day, the Walmart, the fake phone call. But let's talk about another day. Mary Bartell, God bless her. Wasn't she cute? I mean, come on. She was witty, funny. I don't know if you noticed, but to me, a person that age, a barometer of how cognizant they are and their neuromotor skills and their ability to remember. Did you notice her signature when she signed that picture? You can go back and look at it. Okay? It's like they taught us to write. Cursive in the old days. And it's beautiful. And it doesn't have any squiggly lines. It's straight. And you saw how she answered the questions. If she didn't know something or didn't understand it, she told you. Everything else she told you. She didn't overplay it. Okay? She told you what she remembered, what the truth was. And the truth was that somebody went in that house. Okay? And you know who it is. Got the phone there. Got everything. And tries to kill her. But for the pacemaker, she wouldn't have been there. And what happens right after that? I mean, this, don't forget, 9:30, 10:30, so, people are starting to figure out what's going on, friends and what have you. But at 10:31 or 10:29, we get off of his OfferUp account him taking a picture. Doggone it. Got your geolocation.
Mr. Crusoe, you've used 25.
Thank you. Where'd that put? Right there, here's the phone. Put it on for sale. You heard Mr. Saleh, sold it to him, receipts corroborated. Ms. Harris, this is the easiest one, of course. He didn't have a chance to sell anything and put it on OfferUp because he was headed home. Okay? It just happened. They were all on top of it and they understood what was going on. They stopped it. What does he have for keys to her house? The $2 bills, these quirky little $2 bills. Can you imagine that, getting a happy birthday card or Christmas card from her? What's going to be in it? From the evidence. A $2 bill. Okay? She's just quirky like that. Well, her idiosyncrasies, she has hers. Okay? But what else? Dead, smothered, etc. Okay? Keys, money, jewelry. You saw the pictures, the Kim. That's her. That's her stuff. Those are her items. That had the Plano Police Department not been on top of this and not stopped him, would have been up for sale somewhere, somehow, to somebody. And just like he saw him go into that Diamond Gold Exchange, You see that big smile on his face right after he had smothered someone? This is work to him. This is effortless to him. This is what he did. You've got it laid out. I'm going to ask you again. Follow the law. Follow the evidence. You put all this case together. You read the instructions. We have proven, beyond a reasonable doubt, that there's only one verdict in this case that's appropriate. And that is that Billy Shamiri is guilty of the offense of capital murder as charged. And now that you sat here for these 5 days in this courtroom and listened to this testimony, you know, this is our lives. This is what we do every day. But when we call you down here, sometimes it's a little shocking to see the evidence and the autopsies and this, that, and the other. But you know the other thing that's very shocking to people? And you watch me just take a few steps back. And you imagine the difference in the space between where you are and where I am. What this evidence has shown beyond a reasonable doubt is you have been in the company all week long of a capital murder. And I'm asking you to return a verdict of guilty as charged for the offense of capital murder. Thank you.
Thank you. And Mr. Warren or Mr. Hayes, who will be going first?
Thank you.
You're welcome. Yes.
Good morning, ladies and gentlemen. I'm going to talk to you for just a few minutes. I'm going to go over a couple of things with the law, and then Mr. Warren's going to cover the bulk of what we have to talk about today. I would like to point out just a couple of things. You heard Mr. Frizzell here today. He used the phrase, "We don't need help." Does that sound familiar? Because in Bordier, he said it 6 or 7 times. I started counting after the third time, but he kept telling me, "We don't need help." Why? Why does he keep saying that? We don't need help. It's important for him to get that point across to you that we don't need help. And by the way, he's talking about the state. And once you look over here, instead of over here, because not only do they need help, they are begging for your help. They are begging that you plug in the holes that they cannot. They are begging that you do not follow the law. I don't know if you noticed this, but he uttered the phrase, "We don't need help," more times than he uttered Miss Brooks's name. And that's the only thing we're here to figure out this week. I suspect some of you, whenever you heard all these other issues come up, thought in your mind, did they forget we're here to talk about Miss Brooks? Did the state forget that the indictment lists the name Miss Brooks? Now let me answer that question for you. They didn't forget. They're just hoping y'all did. They're hoping to fool that you guys forgot that that's what this case is about. So they bring in cell phone data that's consistent with being someplace, but it's also consistent with being 200 other places. And they bring in DNA on a totally different case, which is unusual. I don't know if y'all caught this, but the only DNA that linked Mr. Schmierman to the scene of Ms. Williams was handled specifically by Detective Kirby Artie, the lead detective that you did not hear from. He picked it up and dropped it off at his leisure. And the only DNA of any substance that the octonians that Mr. Frizzell likes to talk about was found a year later in a wadded up glove of a glove box that had been in a car in Texas heat for a year in a fenced off lot for a year. The DNA analysis or analyst told you that heat would have degraded the DNA. That's why we either keep it at room temperature in a refrigerator. Yet a year in Texas heat was top DNA you saw. Octillion, septillion. Wonder why. You didn't see evidence of DNA that linked back to Mr. Schmierman prior to Mr. Kirby Artie or Detective Kirby Artie having access to his logs, his samples. Interesting, I thought. But there's no DNA that links into this works. There's nothing that links into the case of Miss Brooks. to talk about what's in the charge. In order for somebody to be guilty of capital murder of Miss Brooks, they would have to prove you first that she was murdered, even though the police didn't think that. Medical examiner didn't think that. Actually, had to go back and change his mind based on what the police told him. You would have to first believe she was murdered, but you also have to believe that it was either in the commission of a burglary or a robbery, which means they would have to prove you that someone entered her house without consent. We don't know if anyone entered her house, nor do we know if they did, how they got in there. And the only way you can answer that question is to yes. And you're not allowed to do that, or to speculate. You don't know if someone was invited in and something went south, or what. So they can't prove murder. Robbery, that's in the course of committing theft could cause bodily injury. Nobody knows. Not only was any force used, was anything taken. In order to get any kind of time frame, you would have to guess. You would have to speculate. And you're not allowed to do that. But they sure would like to help you. And just bypassing all that. Mr. Cameron must be a bad guy. So let's forget about the law, forget about the rules, forget about the lack of evidence, and just jump right to the guilty. That's the help date technique. We'll talk about one more. Maybe two. But at least one. Mr. Crusoe, the last thing he read you from this charge was what we call restraint. Well, let me talk about theft. Theft is a lesser included that's in this paperwork. Theft means you either took it or you got it from someone who knew it was stolen. That's what that part required, said property knowing it was stolen. You either took it or someone took it and gave it to you to sell. That's the closest thing they can come to prove in this case, and that's why it's in the charge. That's the closest thing they can prove in response to Mrs. Brooks. And that's why you're looking at it. Now, extract. Mr. Crusoe read this, and I'm going to read it to you again. Unless you find and will leave beyond a reasonable doubt of any extraneous offenses, you can't consider it. But if you do consider it, it's for the limited purpose of motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, type of accident, and for no other purpose. And I thought it was gracious that Mr. Crusoe said we're okay with it, because that's the law. So it's great that the DA is okay with it. But what does that say? Did anyone hear me read the word substitute guilt for one crime for another? They put on other cases hoping, they have stronger evidence, and they're hoping you think, oh, if you did these, you must have done this. They're hoping, that's the help they want. They want you to misuse this extraneous definition and substitute the word guilt. If he did A, he must have done B. But that's what you're not allowed to do. You can only use that for specific instances. For the few things that are listed. Could you imagine how this system would work if a jury could convict someone based on other bad things that the state wanted to get into? That's why this specifically exists. The stuff you've heard the last few days isn't easy. And it certainly wasn't fun. Nobody wanted to be here, and I suspect y'all didn't want to see it. But they wanted to show it. And they wanted to show it to you to inflame your senses. They wanted to show it to you to make you hate Mr. Junior. And they wanted to show it to you so you would help them bypass the law and jump right to it. You're here to decide one thing today. Did they prove to
Thank you, Mr. Hayes. Mr. Warren?
Thank you. Good morning, ladies and gentlemen. Good morning. I also hope that you guys are well. Give me just one moment. I need to grab one thing. Okay, let's get started. So let's think about, I want to take you back to a week ago today, last Friday, when I had the first opportunity to speak to you 14 who are now civil before us and compile this jury. The reason that each of you are sitting here in this courtroom today is because you either verbally or by your silence last Friday told me that the answers that you gave were true and honest. And that was what you took then. And on Monday of this week, you took a different oath. You took an oath to follow the law. And the same way I held you to your oath last week is the same oath I'm going to hold you. The same way I'm holding you to your word this week is that you're going to follow the law. One of the things I also talked to you about last week were your duties, rights as a juror. And I think you know now why. Because each one of you have to make up your decision in your mind regarding whether or not the state of Texas has met their verdict. For each, what I told you last week, for each and everything that they present to you, every piece of evidence that's admitted, you make the determination of how much weight to give. The admission of the evidence is just that, it's admitted. But it's not a given. You see, Mr. Crusoe said because we didn't refute. Because here's the thing. The admission of the evidence is just that. The court makes a determination if it's legally able to come into the court as evidence. But then you individually make a decision of how much weight and credibility you give. And after I speak, and then after Ms. Martin gives his summation, then you guys are going to go back and you're going to start deliberating. What did we talk about with deliberation last week? Very important. What did we talk about? Think about it. For one, you have to respect each other. Each and every one of you have to respect each other. Respect each other's opinions and decisions. Two, it's not your job to change your fellow juror members' mind. I'm not telling you not to deliberate. I'm not telling you to discuss the evidence or lack thereof. But it's not your job to change his mind, or her mind, or her mind. That's why there's not a definition of reasonable doubt in this charge. It's because everyone's is different. Based on their life experience, based on the value they may place on something. Something they may devalue more than you. And thirdly, your job is not to reach a decision. Your job is to evaluate the evidence and to deliberate. If you can reach a decision, that's great. But as a whole and as a jury, if you cannot, that's okay too. You evaluate the evidence, you deliberate, and then you stand there. And you have the strength and respect for one another to hold your position and to respect one another. Health. Like my colleague, Mr. Hayes said, Mr. Crusoe has used that term repeatedly. Last Friday, this Friday, we don't need your help. what's better than what someone tells you is what they show you. And what did the state of Texas show you this week? That not only do they want your help, they absolutely need your help. Because like Mr. Hayes pointed out to you, we're not here for these three ladies. You won't see any of these ladies' names in this charge that the court is going to give to you. There is one person's name in that charge, and that's Mary Brooks. That is it. And I don't want to get bogged down too much in these other cases because, Mr. Fitzmar, he's going to get up here, he's going to pull stuff out, he's going to put his gloves on, and he's going to show you all this evidence on those three ladies below Miss Brooks. Not that he doesn't want to show you evidence for Miss Brooks. He doesn't have any. He doesn't have any. All this DNA, keys that unlock, all this other stuff, that's what he's going to show you. And then he wants you to assume that, and that's if you believe it, the evidence, that he's going to parade in front of you regarding these ladies. Because we don't conceive that either. And the only way you can even consider whether for plan, motive, lack of mistake, lack of accident, motive, habit, is if you believe each and every element regarding those cases. Each one of you. You have to believe each and everything beyond a reasonable doubt. The highest burden of proof in this state and across this country. For everything that they present to you, to even consider that for any of those reasons, you have to first believe beyond a reasonable doubt. And I submit to you, there's doubt in those as well. Ms. Bartell, all she said was gloves. That's it. Couldn't identify his race. Couldn't identify any sort of accent. Ms. Harris, no one could place a car or an African American man anywhere on the street in that neighborhood close to her. With Ms. Williams, it's DNA. Mr. Hayes talked to you about the DNA. A year later, in an unsecured car, rubber gloves in a glove box for over a year. Still have good DNA on it? You make this decision. Is that good evidence? How much weight should I give that? Hey guys, I don't know about that. I don't know. I don't know about that. I'm gonna lower that credibility there a little bit. But we're here for Mary Brooks. They did the accusing. They get over here and they walk back and they look at my client, Mr. Shamir, and they point. They yell, they scream, they tell you how bad a guy he is, all these things. What else did we discuss last Friday? Each one of you, I looked each one of you and we may not have had a conversation, but I looked each one of you and I said, there's a difference between two things. Innocence and not guilty. You may be sitting there saying, Mr. Warren, he's not innocent. But he's not guilty. There's a difference and there's a stark distinction. The presumption of innocence alone is sufficient for an acquittal of Mr. Shamir. And what did I tell you the difference of the normal saying of presumption of innocence? Guilty until. I told you I hate that word, until. What's that mean? Until means you're waiting for something to occur. I'm going to wait here until the bus arrives. So it's not innocent until guilty. It's innocent unless. And that he's draped in that presumption. And it remains with him throughout. So let's talk about Ms. Brooks. And here's the funny thing. Every expert that the state presented to you and put up here, What is the one consistent word that everyone uses up here? Opinion. It's my opinion. What's an opinion? It's a guess. I don't find this, I don't find that. It's a guess. And they say, well, I've had this number of hours of learning this, and I went to this school, this education. So it's an educated guess. But it's a guess. You know, you put these big boards up here, covered up the whole room. I mean, it was an amazing presentation. That's all it is. It's a presentation. But think about what they could tell you and what they couldn't tell you. And one thing, there's a little play on words, but it's very important. Whether it's a slip or not, I'm assuming it's a slip. They were saying, well, Mr. Schumer was here, and Mr. Schumer was there. The evidence does not show that. What the evidence shows, if you believe that evidence, because once again, the call detail records, the real time, all these things, you got to make a determination whether or not you believe that. Just because it came from here, because a special agent comes in and tells you, doesn't mean you have to buy that. Doesn't mean you have to believe that. Doesn't mean you have to have high credibility for it. Each one of you has to make that decision whether or not you believe that. But even still, let's say that you do. It's the device. It's the device. And even then, with the device, it's in the area. And then, they have these cute little, and I'm sure they're going to set it up. It'll be fine, so you see it a little bit later. But they have these cute little symbols on the real-time maps. Where that Mary Brooks here, and Walmart there, and Heritage, all these things. But you know what else is in those areas that they're saying that the device is? Lots of other things. Lots of other addresses, lots of other stores, lots of other locations. But that doesn't benefit them for their weak case to say those things. And here's another thing. Mr. Agnostic stood up and he told you, think about the questions. Well, let me use that term loosely, question. Think about the questions that he was asking agents when they were there. As he rattled off all this stuff, and at the end, he then put a little question mark at the end. And said, well, isn't it consistent? Yes, it will be consistent. To be here or to be there. You could put anything in that general area to say it'd be consistent. But still, mind you, it's the device. It's only the device. And especially on that day of January 30th that we're talking about. Just think about this. When they show Miss Brooks at the Walmart, who can't they put at the Walmart when Miss Brooks is there on the 30th? Mr. Shamir. Did you hear any evidence, any testimony whatsoever that they can actually place him at the Walmart at the exact same time? You did not, because they cannot produce that, because it did not happen. You're saying, well, Miss Warner's a car. It looks kind of like the car that they showed Mr. Schmidt driving. You know, it's an Altima, one of the most common cars on the road, at a Walmart. And even then, what don't they have with the car that they say appears to be? No license plate, can't even see it's the driver, can't see how many other people in the car. Nothing. But they don't need your help. They don't want your help. They absolutely need your help. Because they want you to presume that it's him. And say, well, they're probably sitting back, that might not be enough. So but don't forget about these ladies. Guys, don't forget about them. Forget about the lack of evidence, Ms. Brooks, and while we're here. That has to be his car, right? No, it doesn't. And they didn't prove to you that it is. Because they can't. All those cameras at Walmart, all those clips that Mr. Fitzmark put up there, you think if they had it, they wouldn't have given it to you? They would, but they couldn't, so they didn't. And then, once again, Mr. Agnostis, he took his little marker and, well, isn't it consistent? He drove, yes, well, Mr. Stegler, I actually like Mr. Agent 7. He's honest with you. He said, well, sir, just advice. And secondly, I have no idea if you traveled this way. I can't tell you that. If you believe my data, I can just tell you, it appears that his device is in this area. I don't know where he went and how he traveled from A to B. I can't tell you that. That's honest. I can deal with that. Now, obviously, we know. And Ms. Brooks passed away. So the charge said that you have to believe that she passed away at the hands of Mr. Shamir. And they can't prove that by their own witnesses. That's exhibit number 3. The medical abstract of death certificate from her own doctor. She lists out her medical issues and why they believe it was a natural cause of death. You have Officer Shane Harris from the Richardson Police Department, 30 years experience, decades of experience investigating crime scenes, going to crime scenes. That wasn't even his job that day. He was the second officer called in, and he said, I just for my own sake, I just want to rest well tonight. Let me double check. And you saw the body cam, right? You saw, and not only did you see what he did, but you saw what he saw. They had the camera on, the light on her, around her neck, on her face, around her body, rolled her over, looked at her. No, we're good. So that, and take this stuff back. Just fence exhibit 1. Office of the Medical Examiner Investigation Area. It's yours, so take a look at it. Talk about what he did, what he saw, and what he didn't see. So, here's another thing. So you have Dr. Barnard come here and tell you that it was homicide. But think about this, ladies and gentlemen. I think, what's really interesting is when Dr. Barnard said, in his report, that he saw some bruising and some injury. Well, that's odd, doctor. Because the man that was there that day, Officer Harris, did not. But you say, based on the video and what you saw, that you did. And also, doctor, expert, whatever, still his opinion. Still his opinion. In the absentia report, does anybody look at that? That's what he decides to change the cause of death. And you heard me question. The only things that are different from the field report, the investigation narrative, and the information that in the absentia report is information that you received from the police department. Nothing medical. No physical findings. And here's another thing. Well, let me do it like this. So here's one of the things that he put in there to help him change his mind. The descendant's wig was located on the floor near her body. Is that your medical opinion, doctor? Why this is now all of a sudden not a natural cause of death? front door was unlocked. Well, you heard testimony from her own grandson that she had just come, as well as the evidence you saw, she had just come from Walmart. Okay. There's video, you have their video that she was at Walmart. Okay, we knew that as well. What didn't you hear? Because, you know, when I sit down, Mr. Fitzmartin, he's gonna pop his gloves again, he's gonna grab these pillows, and he's gonna parade them in front of you. What don't we have for Mary Brooks? So they like to call it any instruments of death. Coincidence? Think not. No pillows, no anything. You know, they're gonna say, they're gonna show you pictures of Miss Harrison. She has her face, lipstick is smothered. They're gonna say there's bruising. They're gonna say there's teeth there. Even with Miss Bartell, excuse me. There's bruising. These other things. There's no evidence that this works. No evidence. So then, you know, they have this ring. This ring that they're saying is Miss Brooks. Once again, everything that they submit, every witness that they put up, is in charge. You guys made the determination on the work. Take it back down, look at it. Take the appraisal. Take the picture. Listen to the things Ms. Brooks said and didn't say. Her daughter. Make the determination whether or not that's the ring or not. Then they bring in Mr. Nisanoff from Dallas Golden Exchange. Say, oh, well, on the 31st, he brought in something. And that's what the receipt basically said. Something was brought in. Nothing particular, no details. We don't even know if that's the ring. They're going to tell you it is. They want you to presume. Hey guys, assist us, help us. We need it. Ladies and gentlemen, that's Friday. We spend an exorbitant amount of time talking about the reasonable doubt in each and every element. And now you know why. Now you know why. Because although they may want it, although they may need it, the law does not allow for you to assist or help them. It doesn't allow. Because I will submit to you, if you feel like you need to aid, assist, and or help, then what does that mean? What does that say? That you probably have a what? Reasonable doubt. And when you have a reasonable doubt, that means that they cannot meet their burden. And the reason that you are sitting here is that you told me. You told me, each and every one of you told me that if they couldn't meet their burden, you had a reasonable doubt. Regardless if you thought you did. Remember what we talked about. That's the only reason you're sitting here. Because I get it, I told you. I said, my father's the kind of guy, well, look, son, I mean, where there's smoke, there's fire. I said, well, Dad, it didn't work that way. They have to prove it all to you beyond reasonable doubt. And if they can't, then in this charge, that means that the law says that you have to. You might not like it, but you have to. You have to acquit. And the reason you guys are sitting here, each one of you, is because you told me that that's what you could and would do. And I absolutely submit to you that the evidence is not sufficient that they provided to you regarding Mary Brooks. Mary Brooks. Remember why we're here? That idiom that Mr. Hayes said, forest for the trees. Y'all ever heard that before? But see, it's a little bit different here. See, because in the idiom, you can't see the tree because of the forest. They don't want you to see the tree. They want you to stay over here focused in the forest and on the forest. Because the tree is insufficient. Ladies and gentlemen, I want to thank you for your time, your attention that you've given over the last week. I really appreciate it. On behalf of my client, Mr. Shamir Mir, I can tell you that he appreciates it. And I appreciate the fact that you told me last week, that this week, when you took this oath, that you would follow it. And I believe that, and I trust you. And I'm going to submit to you the only right and just verdict based on the law and lack of evidence presented is that you'll acquit my client, Mr. Billy Shamir. Thank you.
Thank you. Mr. Fitzmartin, do you need a moment to get set up?
How much time do I have?
31.
Please, court,
You may.
counsel. Ladies and gentlemen of the jury, I don't ever want you to forget the name of Mary Sue Brooks. I want the last thing on your deathbed and the accomplishments when you think of them and you list them off is that in the case of the state of Texas against Billy Shamir, where Mary Sue Brooks was the victim, that you did the right thing. That will be part of your legacy. Don't ever forget the name Mary Sue Brooks. If you today, at the end of the day today, when you go to bed, start to forget the name of Billy Shamir, that is fine. But don't ever forget the name Mary Sue Brooks. That is what we're here about today. You know, the way this system works is everything that you've seen me use here and all of this, I have to give to them first. And they've had it forever. I have to deliver everything to them. They don't have to return anything to me and tell me anything. Now, they don't know what I'm going to argue. I'm sure they've guessed and guessed somewhat well, but misplaced. I don't know what they're going to say when they get up to argue. Did you see a flurry of me trying to change this PowerPoint? I don't know if you all have ever used PowerPoint. It takes a while to put it together. Did you see me change one thing on my computer as they spoke? No. And what do I want to start with? Is Mary Sue Brooks. I am not going to ever ask you to forget that case. And there is a part of me in figuring out how to present this to the 14 of you all that thinks I should have probably just stopped with the evidence of Mary Sue Brooks and closed this case out on Monday and let you deliberate and come back with a verdict of guilty. Because when you saw the evidence linking Mr. Shamir being at that Walmart that day parking exactly next to her and driving out in the exact moment in time that she is driving out, and the next day having a unique ring, a cherished heirloom of her family in his possession? Do you need anything more? Does that case stand on itself, by itself? Is that not enough? When you add to that, his device is at Walmart and then follows in the same direction as her house, to her house for 45 minutes. What is he doing in there for 45 minutes? He killed her, and then he went through her things, methodically, calculated, in the middle of the day, with no care whatsoever as to what may or may not come across him. In a community of however many houses in there, of other people, a close-knit community. Her grandson lives down the way. Not a care in the world goes through her items. Don't ever forget Mary Sue Brooks. And we don't need any help, but justice does. Justice needs your help, and that's what you're here for. I can't do it by myself. The Plano Police Department, the Richardson Police Department, the Dallas, with the FBI, they can't do it without you. That's the help we need. Well, who is Mary Sue Brooks? You heard about her. Her daughter thought she was funny. She loved to have meals. She loved to bring her family together, this close-knit family. Her grandson, her daughter lived next to her before she passed away. Her grandson allowed to live there. A young couple, starting out in life. And yet they still want to spend time with their grandmother. Dinners, meetings, no poppins. But dinners, fun times. Never forget Mary Sue Brooks. Now, can I tell, though, really and truly, how we get to solving Mary Sue Brooks without these other women? Without their tragic stories, sisters connected in one horrible, horrible story. All connected by that man. Maybe they would have been friends in life, I don't know. But unfortunately, their connection now is through Billy Shamir. And I cannot tell the story of Mary Sue Brooks without really getting into these other stories. Why? Because we know that this is how she is found. And yes, that night, a trained police officer found no signs on that body that would lead him to believe that foul play. Well, guess what? A doctor, a medical examiner trained in these things, looked at the body of Martha Williams, two of them, and they didn't see any signs either. What does that tell you about the craft, about the ability of Billy Shamir to take two women, to put his hands on them, and to leave them without a trace? Without a trace. But what happens the next day? Hey, where's your ring? Where's your safe? Where's the other items that what happened to them? Richardson Police Department, what's going on? We can't find these things. Can you help us out? They wait 3 weeks to drill the box. They're not in there either. He knew something just wasn't right about that. Martha Williams' family told him the same thing. He knew something just wasn't right. There were things missing. Mary Bartell told you in her own words things were missing. These stories overlap. You cannot know one without the other. They did do some investigation though. They figured out she was at Walmart. Her things, her groceries, thawed. We know what day it happened because of the blood pressure pad. We know exactly what was happening with her on the 30th. Do not forget Mary Sue Brooks. Mary Bartell, Mary Brooks' case goes cold, right? They don't know. They don't know that they have a guy like Billy Shamir that's capable of doing this until you meet Mary Bartell. And Mary Bartell's able to tell you that yes, I was at my house. I was doing my normal routine. Go to church, come home, eat a little bit. I made a phone call to my sister-in-law. I was sending an email. There's a rapping on my door. The same routine I have every day. I get up, I go eat, I go have exercise, I take a little nap, and then I do my afternoon activities. Right? These are individuals that have a routine. The routine that Billy Shamir was looking for. Remember? He was at her apartment just a few days before that, watching, learning, scoping out like a hunter would. She tells you that her ring, a ring that she had on her hand for 50 years, given to her by her husband, a sign of love, a sign of admiration, something that should be passed down to her sons, to her daughters. Gone. Well, the Plano Police Department goes to work on this attack of this elderly woman. And they talk to the 5,000-old shepherd at Preston Place. They get a suspicious person a few days before, Richard Kling. We have a license plate. They go to work on the license plate. Well, this license plate of this car that's doing all of this stuff is in someone else's name. Tom Unding's name. How clever is that? Let's get a car that looks like every other car out there, like Mr. Warren says, and let's put it in someone else's name so that when I'm doing all my stuff, no one's ever going to come back and look at me. Okay? They get a name, they get it up, but fortunately, he wrecked out in that car a couple of days before, so they have an accident report. They have his name. They have his address. They are able to figure out his phone number, and so they go to work on that. You hear from the detectives. All of these detectives are sitting up waiting for Billy Chamirmir to show up at his house. The best place they think they can find him, where he's expected to be, back home. It's the next day, the 21st. And when they get there, sure enough, here comes Billy Chamirmir after having passed by his spot, going to the dumpster, and getting out of his car and then getting back in and parking. He doesn't want to get out of the car. Remember that? He's shocked. He cannot believe it. Finally, the game is up. The police have got their man. The game is up. They have to get him out of the car. They put him down. In his hand are these items. Right here in front of you. A hat, some gloves, a hat, a phone, jewelry, unique jewelry in his hand. They go back to the dumpster. What do they find? A jewelry box. Inside that jewelry box, they find unique items. Names, a Lou T. Vang here. Things that would police officers take to use and to investigate. This is now the Plano Police Department. What the Plano Police Department doesn't know in their investigation of their Plano case is that they're hoping to solve a Dallas case. Because we get the name, we get the name tag. They go to work on it. There's only really one other Lou T. Vang that really matches this, and it's Lou T. Harris. And so now we're introduced to her tragic story. And when they follow down to where she lives at 6609 Warm Breeze, their fears are met, and the revelation is had that inside that house, lo and behold, a dead woman. Billy Chamirmir, they just happen to stumble across, Billy Chamirmir at his house, they just happen to stumble across that he has things in his possession that belong to another dead woman. What else does he have on him? The keys to her house. Let me ask you this. Why do you think he kept the keys to the house? He threw out everything else he didn't want. And yet he kept the keys to her house. How much comfort must there be in his mind that maybe there's a time I can actually go head back there to that house full of all that stuff? You met through Rick Reiner, Lou T. Vang, and he told you about this jewelry that she's wearing on there, this unique bracelet, this green ring. You see it there? You see that ring on her hand? And this bracelet on her wrist? Right there. It's the same one. Unique items. Treasures to her and to her family. Items of just greed to Mr. Chamirmir. They know the story of Mary Bartell. So what do they go and look at and find and discover, not knowing that it's there? The Dallas Police Department? A pillow with a spear on it that matches her mouth and her lipstick. I can't tell Mary Sue Brooks' story without this, without you understanding what he does and how he does it. The same day that pillow's getting collected, in Plano, another pillow is getting collected. A pillow belonging to Martha Williams. Another stain. The consistency, the pattern, it's overwhelming. Now we introduce Martha Williams, another woman, loved by her family, moved in a couple of, less than a year before from her own house to a nice, safe community where she thought she could live out the rest of her days in comfort with other individuals who were just like her. What she didn't know was that Billy Chimera is casing that place and hangs out there. We find her on March 7th, but we know that it was March 4th, was the day that she passed away. How do we know that? Because of her medication, because of the communications that failed on that day, because of her receipts, because of her car. When they go back and look at this pillow, unbeknownst to, while we're on this subject of Detective Turbiarte, do you know how long I spent and how much time I spent bringing you all the pictures of everything and how it was collected? I brought you everybody that came in here and collected every piece of evidence and how it was all these pictures of how they were taken and how they were brought over and they were untampered and unmessed with when they got to the UNT lab. Why? Because I kind of figured, well, they're probably going to say, even though we didn't need a subpoena, because they could have brought Detective Turbiarte, they thought anything was wrong about it.
Because the objective shifting the burden, Judge, their burden to prove your case.
I'm proving it, Judge.
That's overruled, and you may continue. Ladies and gentlemen, closing arguments are just that. It is not evidence from either side. You may continue.
Ladies and gentlemen, his DNA's on this pillow. It has no business being on her house. They go back, they look at her fingernails. They cannot be excluded as a contributor to the fingernails on there. The blood stain on that pillow, the DNA under there. What did Holland Williams tell you? Her mom's a fighter. What did Dr. Bernard tell you? This would be a struggle. This would be something that people would reach out and lash out for and try to gain breath. Try to do whatever they can. These women had lived these long lives through all kinds of issues and things, and there was pandemics before this. There was wars that they lived through, and yet when we would expect that their final days would be of rest and comfort, no, it's struggling. It's struggling for the last breath that they will ever take, because Billy Chimera has a pillow over their face, scratching him, collecting his DNA from him. They go and look in this car. They collect the car a year later. This car was in the Dallas Police Department. Plano Police Department goes and gets it, looks inside it. The first time ever you find gloves in a glove box, right? No one ever keeps gloves in a glove box, but here he does. And when we look at this one unique glove, this blue glove, it's got her DNA on it. To the 1 in 130 octillion. Her DNA in his glove box. What does that tell you? That confirms Mary Bartell. What does that tell you? Why do we not have fingerprints at anybody else's house? They ask about, did you collect any fingerprints in any of these? Why? You can't leave fingerprints when you got a glove on. Mary Bartell tells you he has gloves. Martha Williams convinces you that he has gloves. Is it not too crazy to think that in Mary Brooks's case, he wore gloves as well? Why don't we have a pillow from Mary Brooks's case? I told you, she's found on January 30th first. They don't go back to look at her case until after March 20th, when he's discovered as this killer. Those pillows are already gone. There's nothing to compare him to. We don't even know which one it was. She's in the living room. They look inside the trunk of his car, inside this blue bag right here. And what else do they find? You don't want to believe DNA? You think there's something wrong with the DNA in this case? Well, look inside here. Unique items. This bowl. Creamer. This creamer. A wedding gift, she believes, to her mom. Lived with her mom for all those years. Now, something to be carried around in the trunk of Billy Chamirmir's car. Something to be got for, something to be earned. His earning, his job. That's part of his job right there. Let's go back to the investigation. One being done by the Plano Police Department and one being done by the Dallas Police Department almost simultaneously. They have two different cases that they're working on. One's trying to solve Lou Harris. The other one's trying to solve Mary Bartell. So let's start with Lou Harris's, okay? And they have this Walmart receipt. Well, let's go get some video of Walmart. Let's see what we find. Hey, we found Lou Harris, right? Let's see if there's anything else in there. What do we find? Billy Chamirmir, the same guy. Just minutes before checking out. You remember the other videos where he's walking up, looking down her aisle, coming back, and then checking out, and waiting, and waiting, and waiting, and then right together. So they go and get more video, right? And what does this do? The Dallas Police Department gets more video that helps the Richardson Police Department. Is this a big conspiracy where you get Dallas and Richardson and Plano and the FBI and the UNT lab? Everybody to let's just all go frame Billy Chamirmir all of a sudden. No. They are following the evidence as I would ask you to follow the evidence. And what do we find? At 10:53, Mary Brooks is walking into that Walmart, and unbeknownst to her, over her left shoulder, sitting in that Altima that we showed you the video of, is Billy Chamirmir. Sitting there. Right there. Remember that? Remember, this was from earlier. Remember, he was at that Walmart 3 times that day. First he came, he parked, he walked in, looked over, turned around, got back in his car, and then left. Then he comes back again and parks at this time and sits there. He goes inside, remember he has the exchange with the woman. He goes inside, he buys an orange, a Lunchable, and sits there for about an hour. Facing what? Facing these parking, the handicapped parking spots. His favorite little hunting spot. We know that was the same day that she died. Why? Because she's wearing the same clothes. Right? You can see here, this is him pulling in. He's going to wind up parking right next to Mary Brooks. And then this is him leaving that spot. That's not working. Anyhow, you know he parks right there. That same Nissan Altima. And this is her. She's right next to him. When she pulls out, he pulls out. Why do you think he likes this Walmart? What do you think it is about this Walmart? Well, there he is on his phone. Look who's right behind him. There he is walking in, looking over. Here he is walking in again, and another time. Who does he see? Walking in again, coming right out against him. Again, looking over. You've seen all these videos. You've seen what he is looking for. These women, each time. That's his hunting ground. You remember this exchange with this woman here? When he comes in this, there again, I won't play, but you'll remember it. You remember how they have that exchange? He helps her with the basket, and he gets this stuff, the trash out for her, and she pats him on the shoulder. That's how. Do you remember what Mary Bartell told you? He spoke Eldorese, right? He knew exactly how to do it. How do you think he gets into these houses? How do you think he's able to communicate and look and interact in these different environments without being seen and without being noticed? He's practiced his craft and his trade. They want to say that this was in Mary Brooks's case, that maybe she invited him in, this stranger, into her house, and then just said, "Here, take all my stuff." Maybe that's how this became not a burglary. Well, ladies and gentlemen, once you're in there and you put someone down on their ground and you put a pillow over their face or you do some sort of homicidal violence to them, that is a burglary at that point in time.
Actually, Judge, that's mistaken of
That
the
is
law.
not a mistake of the
But
law.
it's a mistake of the law.
Gentlemen, one person, black robe. So your legal objection, Mr. Hayes, is?
Well, he's mistaken the law. Right? The law's what's in the charge, and the jury's entitled to rely on that law and not his interpretation of it.
And to that, I will sustain that objection. Mr. Fitzmartin, just stick to that law that's in the charge. Thank you.
If you get into someone's house and you enter that house with the intent to commit theft or with the intent to commit some sort of other felony offense, that is a burglary.
That's not what it says in the law. It's just not. He can't leave out half the law and ask him to apply it.
I've already ruled. However, ladies and gentlemen, you will have a copy of the court's charge to read all of the instructions as well as all the law that is given to you by the court. As I've told you before, this is summation. You will recall all the evidence and testimony that you heard in this case. Mr. Fitzmartin, you can continue and I'll give you some minutes back.
Thank you, Judge. Ladies and gentlemen, do not forget Mary Brooks. Do not forget. Oh, let me talk about Mary Bartell. When we go to Mary Bartell, remember I told you that Dallas is working on Walmart? Well, Plano's working on Mary Bartell's case. The offer-up records, okay? They get the offer-up records to try to prove Mary Bartell's case. And sure enough, it does, because she signs that piece of paper right there that says that is her ring. It's a ring she had for 50 years. Then we see that we track that, and he's selling that ring down at Starbucks to Abdel Saleh. What do they do when they look inside those same records? They find Mary Brooks' ring. The same ring that her grandmother that her mother owned, that Ann Brooks' grandmother owned. The same ring was soldered underneath. That Ann Brooks says, I know for a fact that is mine. We brought in William Noble, the owner of the company, to say that ring and that ring is the exact same ring. We brought you records from Diamond and Gold Exchange. You remember the pattern in all these things? He would go attack someone and then go directly to Diamond and Gold Exchange. March 4th, on the left, that is the day he goes in for Martha Williams, getting about $3,000. March the 19th, that is Mary Bartell, 105, having just gotten $380 from Abdel Saleh. What do we have on the 30th and the 31st? Also selling Mary Brooks' items at Diamond and Gold Exchange for a little over $5,000. That's the worth that this man believes that these ladies' lives are. Don't you think all of these women would have given him that money if they needed to? Just for maybe one more day, one more meal, one more breath? Absolutely. This is him, smiling the day of Martha Williams. He just did a good day's work that day. He just put that pillow right there over her face. If we had cameras in the parking lot, we'd find that Ultima in the glove box, those gloves with Martha Williams' DNA on it. These items here in the trunk. I can't tell you the story of these four sisters without. I can't tell you Mary Brooks without telling you about Mary Bartell. I can't tell you Lou Harris without telling you about Mary Bartell. I can't tell you Martha Williams without Mary Bartell and Mary Brooks. They have been intertwined in the web that Billy Chamirmir has cast. I don't need your help. The evidence doesn't need your help. I just need your common sense. That's all I need. And when you put all of this evidence together, you know exactly what happened. Billy Chamirmir. Billy Chamirmir is what happened and brought this death and this destruction to these families' lives. You know, I'll be a lawyer 25 years in November, and I've spent every day but down here. And these are the laws that we live by, and I do encourage you to read that court's charge and see that we have filled out every part of what we're supposed to prove to you here today. But you know, the laws that are in here that prohibit things, they're all pretty much driven by the 7 deadly sins. You've all heard of those. You know, sloth, envy, pride, rage. That's pretty much what it comes down to. Billy's, Chamirmir's, it's greed. That's his 7 deadly sins. And you know, when you think of some of those like rage or lust or gluttony or whatever, some of those might be brought on by some sort of mental condition. You know, maybe he doesn't excuse something, but it might explain it. There's no real explanation for greed. You know, it's a difference between greed and just wanting more, or wanting a better life. Okay, that's what this country is built on, is wanting more and wanting a better life. People come here from far away. You've heard of them here: Luke Harris, Tom Onding, Abdel Saleh, Gilad Nisanoff. They've come here to carve out a career, carve out a life for themselves. And maybe that's what first brought Mr. Tamirmir to our country. But then the greed took over. And greed's different. Greed makes things like humans turn into objects. You know, you've heard of the Midas touch. Everybody's heard of that. Well, that whole story is about old King Midas. Old King Midas, he did a good deed for a god and gave him a wish. And he said, you know what I'd like is to be able to touch something and make it turn to gold. And he was so excited when he got that wish. And you know, but soon that greed started to turn back on him. The meal that he ate turned to gold, and the cup that he drank turned to gold, not taking that pleasure from him. The roses in his garden all turned to gold, which brought him joy at first. But what happened to his daughter? His daughter didn't like that she couldn't smell the roses anymore. He touched his daughter, killing her daughter, turning her to gold. Well, ladies and gentlemen, now you have a new touch, the Tamirmir touch. This touch turns everything to death, to ruin. He takes these pillows, these objects that should be our comfort, things that should be, you know, we use to decorate our houses, that these women probably use to bring comfort to their life and to their house, to give them rest, to give them respite. And what does he do with them? He turns them into objects of murder, objects of greed. Death follows the touch of Billy Tamirmir. When he touches these items that you see, these heirlooms, these things that should be passed down from generation to generation, they now become things of just objects to him. Do you really think that anybody wants this creamer anymore? The thing that was given as a wedding gift, but now was the object of someone's desire to the point where he's willing to kill her for it. The ring of her grandmother, Ann Brooks' grandmother, she wore for a week, melted down, sold off for measly dollars. That's the touch of Billy Tamirmir. Ladies and gentlemen, I don't want you to ever forget Mary Brooks. I don't want you to ever forget any of these women. They deserve you giving them the attention, giving them your consideration, but they also deserve a quick and just verdict. Every minute, when you go back there and you take this charge and you read through this charge if you need to, and you come back to maybe you decide who your foreperson is, there's only one place that your foreperson should sign, and it is this top line here. It doesn't. Although he did commit theft, you don't sign that, and it's definitely not guilty. It's just the capital murder. That's what this case calls for, because justice calls for that, not because of what I say or he says or anybody else says. It's because that's how the evidence has led you. Billy Tamirmir turned these women's lives into his objects of desire and greed and cast them away. Do not cast me away when I am old. Do not forsake me when my strength is gone. These words uttered in the book of Psalms thousands of years ago ring true to today. Our elderly, the most vulnerable of our society, along with maybe children, deserve our protection, deserve to be told your lives meant something. And the police departments in this North Texas community came together and provided the evidence we needed to hold you, Mr. Tamirmir, accountable for your actions. And every minute, every second, you delay your verdict in this case gives him
I'm
hope.
just going to object. That's improper jury argument, and trying to shift the burden. We just asked him to keep his argument within the proper bounds, Your Honor.
Objection overruled. You may continue, and you have 1 minute left.
Thank you, Judge. A swift verdict on your part will take any hope that he has away from him, that someday he might walk free again. Someday that he might be able to go back to 5,000 Old Shepherd or go back to that Walmart. Take that hope away from him, just like he took all hope away from these women, just like he took the breath away from these women. Return a verdict of guilty, because he is guilty. Send a message to this community that the citizens of Dallas County will do what is right. They'll do what is just, and they'll do it in a swift manner, and send a message far and wide that Billy Chamirmir is a capital murder, just as he set out to be. Thank you.
Thank you so much. All right, ladies and gentlemen, you have now heard all the evidence, testimony, and you have now heard all the closing arguments in this case. I will allow you to retire to the deliberation room so you can start your deliberations. On the very top is the official charge of the court. That is the actual charge that's file stamped that your foreperson will sign their name to whatever your verdict form is. We also have exact copies for each and every one of you so you can read the law for yourself. And at this time, we will allow you to retire to the back. And while you're retiring to the back, I would please ask all persons to stand. I'm sorry, Deacon. Was I supposed to tell you get them? You can take yours back.